Hi, I'm Martin Judnich with the Judnich Law Office. Today we're going to talk about what to expect when you're expecting to go to court. You've been arrested and now you don't know what's going to go on. What is going to happen in a court of law? What should you expect? Let's go over it in all of the different things you're going to expect. Well, first comes the arrest. By the time you're watching this video, that's probably already happened. Of course, with an arrest, you do get released from jail two ways. The first way is through posting a bond or cash. The difference between the two is if you post cash, which means cash check, sometimes a credit card, you get that back. So you post all of it, let's say it's a $10,000 bail. You'd have to post 10,000 actual dollars you give to the court or the jail. They hold that until the end of the case. Once the case is over with and you're sentenced or it's dismissed, then you get all that cash back. 100%, it all goes back to you. The difference is if you use a bail or a bail bondsman, you typically pay 10% fee to post that bail. So you're hiring the bondsman to pay the $10,000 bail. You'll typically pay them about $1,000, around 10%, but you never get that back. You pay that fee and it's gone. What a bail and cash bond does, it assures your appearance in court. So it's the judge's guarantee that you're not going to skip, you're not going to say adios court, you're going to show up and deal with your case. So now that we've bailed out, the next court appearance tends to be your arraignment, also called an initial appearance. What that is, that's where you enter your first plea in front of the court. So there's only two pleas at this: guilty, not guilty. That's it. Something important that's sort of an old wives' tale, and we see people do it all the time in court, is it's not the opportunity to explain yourself, to explain your situation, and to give the court a bunch of different information. That is a no-no. All the court wants from you at the initial appearance is a plea of either guilty or not guilty, and that's it. They do not want to hear your story at that time, and frankly, it's not the appropriate time for it. If you want to get it over with, you don't want to fight the charge and you just want to take it on the chin, hey, plead guilty right there. You'll be sentenced right there. But there's no opportunity to look at the evidence. There's no opportunity to look at legal strategies. There's no opportunity to negotiate. If you plead guilty at your initial appearance, that's it. You'll be sentenced right then and there and the case will be over. The better way to do things is to plead not guilty. Now, what happens when you plead not guilty? All you're doing is you're telling the judge, let's start the case. It's a legal procedure, it's a legal tool. Without a plea of not guilty, there's typically no case number, nothing has started, there's no prosecutor assigned to it, you're just one of the many cases that comes before the court waiting for the plea. It's the actual initiation of the not guilty plea that starts a case. That's traditionally where a case number is given to your case, you're assigned a judge, you're in the right court. All those things start to happen with a not guilty plea. So again, not the time to be telling the judge your story, it's simply the time to enter your plea. So once you enter a not guilty plea, that's literally all the words you have to say, not guilty. You don't need to say anything else. The judge will advise you of your rights. The judge will also tell you before the not guilty plea what the potential sentences are, things like that. That'll be discussed with you typically further with your attorney. The judge is just there to tell you about all the charges you're charged with and potential sentences that you could receive. Obviously, you're typically not going to receive the worst penalty there is if you plead guilty right then and there. It's typically the other way. You're typically going to receive something on the lighter end. However, when you don't negotiate with a specific plea agreement, you have no idea of what the court's going to do. Terrible idea. You always want to go into court knowing what's going to happen, or if there's just no knowing what's going to happen, we usually save that for a trial. So, arraignment. Not guilty or guilty, typically our recommendation is not guilty plea. That preserves your rights, that starts the case. Then we start moving on to more court appearances. After you're done entering your not guilty plea, the judge reads you all of the stuff. The judge will then start entering further dates for the rest of your court case. Now, at the arraignment, they're not going to really know how this case is going to proceed down the line, how long it'll take. We have a general idea, but those tend to change. So usually a judge will give you at least one more court date in the future. In Montana, that's called an omnibus hearing, or OMNI for short, O-M-N-I. What that is, it's a scheduling hearing. This is a hearing that starts after the arraignment, but it's a very important hearing. Traditionally, the attorney and the client have to be there together, but these days we're doing things via Zoom, sometimes over telephone. Sometimes you can even file paperwork and not have the hearing at all, just have the judge sign off on it. The significance of an omnibus hearing is this. The judge wants to know, does the defense attorney have all of the information in the case? We call that discovery. That's the police reports, that's the videos, witness statements, all the evidence against you, the person that's charged, the attorney or the defendant need to have well before the time of omni. At the omnibus hearing, that's when we tell the court if there's any issues with discovery, if we haven't received some specific evidence, also if we're asking for something that typically isn't turned over. In DUI blood cases, for example, the crime lab information typically is not always turned over in full. Omnibus hearing is a good opportunity to address that kind of situation. So the omni is where those things are brought up. Another big part of the omnibus hearing is the judge sets deadlines for motions. So at the omnibus hearing, you have a duty as the defendant and the defense attorney to tell the judge what motions you're going to file. The significance of this is if you don't tell the judge about the motions, there's a chance the judge won't let you file them later. Oftentimes they will, but there is a chance. So it's very important that at the time of the omnibus hearing, your attorney is prepared for it, they know what motions they're going to be filing, and they're prepared to file those things down the road. So we're telling the court what we're doing in an omnibus hearing. We're telling them we anticipate these issues are going to come up, and we're going to file these motions. And we typically will then set deadlines for when the defendant has to file motions, when the state may file motions, things of that nature. Once that's all wrapped up, that's the end of the omnibus memorandum. The defendant typically does not say anything at an omni hearing. You do typically have to be there, but just in presence only. You're not going to talk about the case at an omni hearing. You're going to do nothing other than scheduling, and your attorney typically takes care of that. So defendant, you could just stand there, sit there, and really do nothing at that hearing, but that's not a bad thing. So after the omni, that's when it starts to get a little bit different in different cases. Traditionally, after an omnibus hearing, you're going to have something called a final pretrial hearing, maybe a status hearing, or some other hearing that's just sort of checking in on the case as it proceeds. These days, an omnibus hearing isn't happening for months after the arraignment, typically 2 to 3 months, sometimes less, but often not. After the omnibus hearing, then you may be waiting another month or two for the next hearing, so things are not happening very fast, but these are all important hearings. The final pretrial or status hearing is, again, a checking in type of hearing. The court wants to make sure the prosecutor is doing their job and the defense is doing their job. The court wants you to seek some sort of resolution to your case. The court does not want you to take your case to trial. If we tried every single case that goes before a court, that becomes very problematic. The court is urging those involved in the process to get it going, do your job, and actually try to resolve a case. That's called a plea agreement. And going back and forth, we'll talk about that in a second. But the status hearing or final pretrial is a date by which the court's going to check in on everybody and find out, are there any issues that need to be addressed? What things need to happen? Are active plea negotiations going on? And in some courts, they'll even set deadlines that you have to have your plea agreement done and given to the court by. And if you don't, then the court won't accept a plea agreement after that date. So it varies by jurisdiction, but it's a pretty bad idea to go before a court after they've set a deadline saying we need to do this or that. So great idea to have an experienced attorney that knows what they're doing and knows what deadlines they're approaching so that you don't lose any of your rights. So the final pretrial, final status, all that is then leading up to what's going to happen with the case. Are you going to go to a trial or are you going to change your plea? That's realistically the only two things that are going to happen. If there are pretrial motions where, let's say, a legal technicality comes up and let's say evidence is suppressed, let's say there's a technicality that dismisses the case for whatever reason. That can happen, but that will then end the case pretrial and resolve it that way. It doesn't happen in all that many cases. It does happen from time to time, but the vast majority of cases will take two tracks. You're going to have a plea agreement track or you're going to have a trial track. Other than that, there's not a lot of places to go. So what happens with the plea agreement? Plea agreement is a negotiated compromise to a case that the defendant agrees to and the prosecutor agrees to. The judge has no part in plea negotiations, and the judge will tell you that. The judge will tell you they don't have to follow any plea agreement. They can do what they want. Often they will, but not always. The plea agreement's a contract between the prosecutor and the defense, and there's a lot to get into as to how plea agreements work, but in broad terms, it's what you should be expecting the court to do. if you take a plea or accept responsibility for a charge, maybe it's the charge you're charged with, maybe it's an amendment down to a lesser charge, what have you, you're taking responsibility for that plea. You're going to go before the court and take responsibility for that. That's the plea agreement track. The trial track obviously is you're not taking any responsibility for it. You're saying you didn't do the crime you're accused of. Perhaps there's issues with their evidence and you're going to go before a jury or a judge to try your case. Pretty straightforward for what's going to happen with a judge or jury trial. You're going to trial, you're going to put on your case, and you're going to ask them to be acquitting you if you're the defendant, or saying that there's insufficient evidence for the charges that they've brought. Now, the vast majority of cases, probably somewhere around 99% of criminal cases, will be resolved with a plea agreement. That's a negotiated compromise like we're talking about to something. Every case is so different. It's impossible for any attorney to tell you, oh, it'll get pled to this or pled to that very early in the case. That's not how it works. At least not good attorneys anyway. A good attorney will get you a good plea agreement, hopefully, depending on the facts of your case. Good plea agreements only come by with hard work and showing a prosecutor that the evidence isn't as strong as they may seem. Prosecutors are not in the business of handing out great plea and basically ask you, take responsibility for what you've listed in the plea agreement that you're going to plead to. And you of course have the plea choices of pleading simply guilty to a certain charge, which is how the vast majority of charges happen. There's opportunities maybe for what we call an Alford or a no contest plea. Those have different variations where they can or can't be approved by different people. Talk to your attorney about that kind of stuff. But ordinarily, we're going to be taking a guilty plea to a specific charge. That's a change of plea hearing. Something important to keep in mind at a change of plea hearing is that you have to tell the judge what it is you're pleading guilty to and what you did that makes you guilty of that. It is not uncommon for a judge to not accept a plea agreement if a defendant can't take responsibility for their actions. For example, in a DUI case, if you can't say you were driving under the influence of alcohol, that impaired your ability to drive on a certain date, this and that, judge isn't going to take your plea. So you have to be willing to take your lumps and accept the responsibility factually for what it is you're saying you did in the plea agreement. If you're unwilling to do that, judge will not take your plea, and then the change of plea hearing won't happen. They'll probably send you to a trial. So the change of plea is the opportunity to take all that responsibility, get the facts out before the judge so that the judge can take the plea, accept your responsibility, because when you do that, you're waiving your rights. You're waiving your rights to a trial, to challenge the witnesses, to do all that stuff. The only right you don't waive is your right to an attorney. So at a change of plea, you're basically saying, let's get this case over with and let's go to sentencing for the things that I'm pleading guilty to. After a change of plea hearing, sometimes it's the same hearing, sometimes it's a different hearing depending on the kind of case, but at a sentencing hearing, that's when the judge sentences you to the crime, and that's where we're talking about jail, fines, fees, other conditions of judgment and sentence, things like that. Monitoring, probation, all that stuff. That's going to be a long laundry list of options that are in a sentence depending on the type of crime you're charged with. Those, in broad strokes, are the things you can expect for all the different court appearances for a criminal case. Now, all these things can take a long time. It's not unusual for a misdemeanor case to take 5 to 6 months to go through all these things. For a felony level case, definitely not unusual for it to take 6 months to a year to resolve these things in finality. So you got to take your time, you got to do your work, you got to do everything to make sure when you're ready for your court appearances, you and your attorney are ready, you know what is happening at that hearing, and you can anticipate what the judge is going to be asking of you and what the next hearing is going to hold for you so that you don't look bad in front of the court, you look ready to go, and the judge can give you the best possible sentence. If you want to talk more about what to expect with court appearances and what the difference is between, frankly, okay attorneys and good attorneys that can get you through what you need to do, give us a call at the Judnich Law Office. We're here to help you. We can offer you a free consultation for any criminal case. Thanks.